Hello and good morning from me as well. Thank you all for joining our April colloquium, and thank you, Pascal, for agreeing to be our presenter today and to shed more light on this very topical topic for all of us who are working with AI and who all the time have questions what we are allowed to. Before we present the topic, I would like to briefly present Pascal to all of you. Pascal Sierek is a postdoctoral researcher at the Max Planck Institute for Computational Private Law in Hamburg. He completed his PhD at the University of Bonn on the broad topic of data trusts and the legal issues arising from the processing of non-personal data, a topic which can be situated more broadly amongst the legal questions of the data economy and the evolving legal framework and technical developments. He completed his PhD under the supervision of the current chair of the Federal Data Protection Commission in Germany. As to the specific topic, like I mentioned, it's a more legal topic, which probably will make a lot of you aware of or probably help you answer questions in relation to the exceptions in German and European copyright law when processing data for the purposes of development of AI technology, and more specifically, do the exceptions for scientific research purposes apply when developing AI technologies? You see there are a lot of gray zones in how far can we rely on exceptions and not, and what we are allowed to do. We are very happy to have Pascal and especially this topic because we have been addressing a lot of data protection, personal data protection issues, and now this is a new topic on copyright law, which we believe is very relevant for our project, but also for the broader topic of AI development of AI technologies. Before I give the floor to Pascal, who will then go in detail about this topic, I would like to invite you if you have clarificatory questions during the presentation, I kindly ask you to put them in the chat and I will pose them to Pascal so that you're able to follow the presentation, especially if you're not a legal scholar. At the very end of the presentation, there will be a discussion round. So if you have more questions for discussion, more general questions, please keep them then for the end, for after the presentation. With that, I think I have presented enough Pascal and his topic. Then I will give the floor to him. Pascal, if I missed something or misrepresented something, I ask then you can correct me or complete me in your presentation. So here I give the floor to you and looking forward to your presentation.
Thanks so much, Diana. No, was everything correct? And I just share my screen. I hope everyone can see it and hear me. Very good. All right. So, first of all, thanks a lot for having me on this colloquium and also for the kind introduction, Diana. And as Diana just said, today's presentation will cover copyright requirements for the training of AI for scientific research. And I think it's a timely topic because when it comes to research, it's probably not the first thing that comes to one's mind that there might be copyright requirements. And if you follow the public debate around AI and copyright, I sometimes get the impression that training an AI model is essentially a lawsuit waiting to happen thing. So OpenAI is being sued in the EU, Meta and Anthropic are being sued in the US. And everything, it seems like the training in AI carries a considerable legal risk. And I think this is true to some extent. But in my opinion, if you follow the law and especially with regard to scientific research, the picture can be quite different. And before I start, I would like to have a few disclaimers. First of all, I'll be talking primarily about German copyright law, but copyright law is largely harmonized in the European Union. So what I am saying applies more or less also to the other copyright laws in the European Union, but might be different in countries outside the EU. And as I was told that the audience here is interdisciplinary, I decided to just cover the basic and give a broad picture on the relevant legal issues. So there will be no in-depth analysis of certain legal questions. I just want to present the relevant regulations to you and how they might be applied for AI training in legal research. And as Diana said, just feel free to write questions into the chat at any point if something is unclear. Very well. So first, let's have a look at the big picture. The whole debate about AI and copyright is essentially result of fundamental tension. So you need to balance some conflicting interests. On the one side, you have the narrative of AI being kind of the engine of innovations, very important for the competitiveness of European economy. And on the other side, you have very serious concerns of especially creators who fear something that's called art apocalypse, so that the human creator becomes in a way obsolete. And in the middle of this is somewhere a special case, which is scientific research, because society has a very strong interest in advancing research, and the law reflects that in a way that you have in the copyright law, but also in the AI Act and in personal data protection law, certain privileges for scientific research. And right now, I don't really want to explain how AI training works. I guess most of you know that better than me, but I want to give you a legal perspective on this kind of the copyright lens on this process. And some of you might feel that this is kind of oversimplified, but that's, in my opinion, necessary because we need to break things down so that the average lawyer like me has the chance to understand this. So in legal literature and also in recent court decisions, we've come to distinguish three phases that are relevant for copyright questions. So the first phase is the compilation of the training data. Then you have the second phase that is the training of the model itself. And then the third phase, which is the model in action that gives some kind of output. And today's presentation will be on the copyright questions related to these phases. However, before we start looking at these phases in further detail, I would like to have a first look on under what conditions AI copyright becomes relevant for AI training. And this is always the case if a data set contains copyrighted material. Especially is this true when you train a large language model or image generation systems, for example. When is information protected by copyright? So the core concept in copyright is the work. So this is like a form of information where you have some creative element, like an expression that has a sufficient creative originality. For example, high quality photographs, books, text, videos, music, for example. And even when you are somewhere below that limit, where you don't have like a creative element in that sense, there can still be copyright protections, for example, for press publications or simpler photographs. They are also protected as related rights. What is not protected by copyright are facts, ideas, or other technical or scientific findings. So if you have, for example, a purely fact-based data set, say, for example, measurement values or genomic data, then there's generally no copyright protection for that data, so for the individual measurement value. However, what might be often the case is that not the individual element, but the database as a whole is protected by copyright law, in particular when the obtainment of the data constitutes a substantial investment. In this case, you have a database according to Section 87A of the German Copyright Act. And this would be, for example, the case if you have a genomic database, which required substantial financial and organizational investment to collect and verify and structure the data. In this case, you will have protection according of this database. And in this case, copyright law is relevant if you use this data to train an AI model. All right. So let's assume that we have a research project where we would like to train an AI model on a given set of copyright protected data. The question is here, when does copyright come into play? And copyright law essentially focuses on acts of use. That's kind of the trigger for copyright. Whenever a copyright material is used, it needs to be authorized according to copyright law. And the most important use when it comes to AI training is the reproduction. So essentially making a copy of copyright protected information. And copies can be relevant at every stage of the AI value chain. For example, when you compile your training data set, during the training and potentially even in the outputs, you have copies. And today we'll focus mainly on phase one, the compilation of the training data set, but I would also like to flag some risks and recent case law in the training and output phase. What's also important here to say is that everything that I say is hugely contested in literature and case law. So there's really no certainty in this legal debate. So whatever I say, there are countless arguments against it, and I'm trying to present here just what I feel is a prevailing view in literature and case law. So let's have a look at the phase one, the compilation of training data. If you make a copy of copyrighted material to use it in training, then this act of use, this copy, needs authorization. And authorization can come from two sources, basically. Either the rights holder has consented to the reproduction of his work for AI training. This might be the case in some cases when you have, for example, data that was published under Creative Commons license. But in many cases, it's just impractical to obtain a license from everyone that has a right in this data. So you must rely on statutory exceptions. And there are two very important exceptions here. It's Section 60D for scientific text and data mining and Section 44B for commercial text and data mining. And we will have a look at them right now. Right, before I get into details, are there any questions until here, Diana? Okay, so let's have a look at Section 60D. Don't worry about the text on the left side. This is just the legal text. The exception has basically three requirements. The person who's copying must fall into the personal scope of the exception, so it must be a research organization. The processing must constitute text and data mining with lawfully accessed data, and there are certain purpose limitations. And if these requirements are fulfilled, you are allowed to use copyrighted material for AI training for scientific purposes. Yeah, let's start with the personal scope of the exception. Paragraph 60, Section 60D of the German Copyright Act says that the one who's making a reproduction for the purpose of text and data mining needs to qualify as a research organization. And what the research organization is then defined in subsection 2 of the Section 60D. Research organization requires basically two things. First of all, there must be research. And research is kind of a very broad and contested term, but in the copyright context, it means any methodical, systematic activity aimed at generating new knowledge. So generating new knowledge essentially qualifies as research. That's understood quite broadly in a sense, which covers, for example, natural sciences or humanities. And secondly, the institution who's conducting the research or the individual researcher must meet some requirements, must be a university, research institute, or another institution, and it must pursue non-commercial purposes or reinvest all profits into research or operate in the public interest under a government recognized mandate. And here, the concept of an organization is interpreted very broadly. You don't need a particular structure or funding model. You have another quite special case, which might be relevant in some cases when you have a public-private partnership. So you have like a public institution, research institution that is funded by private companies, for example. And here, the exception for the reproduction does not apply when a research organization collaborates with a private company that has a decisive influence over the organization and has preferential access to the results. But what's important here, both conditions must be fulfilled. So if only one is present, say the company has influence but no preferential access, then this exception still applies. All of these requirements seem fairly easy to understand, but can be difficult sometimes. For example, if you take a look at the case of the Lion Association, which I assume most of you are familiar with this, so I keep it quite brief, and please correct me if I'm wrong with my explanation. So Lion is a non-profit organization that downloaded data from an existing US dataset containing over 5 billion image description pairs. So you had like images and descriptions, what can be seen on that image. And Lion developed a software that checked whether the image and the description matched. And if pairs that didn't match, these were filtered out. And the results were then essentially a table of URLs with image and description. And this table was published by Lion. And a photographer whose images were included in the database sued Lion before the Hamburg courts. And one very relevant question in these cases whether Lion was conducting research and if Lion was a research organization. And the court said had to rule whether they were conducting research, and they came to the conclusion that yes, what Lion did was research in the sense of the law, because they had like systematic activity that was aimed at generating new verifiable knowledge. So what mattered here was that Lion developed something new, the software which they were using, and not just running established procedures. And Lion's work, and I guess it's pretty much anything that's involving AI at this stage, qualifies as research because it was aimed at generating new knowledge. And further, the court also assessed that the association has produced publications, for example, so they conducted research. And this private organization did also qualify as another institution that conducted research because it had no commercial purposes, and it made the results available for free. So Lion qualified under the exception of 60D. Right, that's basically the personal scope of the exceptions. I don't know, Diana, any questions in the chat? If there are any, just write it in the chat or interrupt me. Okay, if this exception, if this personal scope of the exception is opened, the next condition which must be assessed is whether the processing constitutes as text and data mining. And this is
Excuse me, sorry, may I interrupt you? A question just came, and I think
yeah.
probably you could briefly clarify it. The question is, what does decisive influence mean? I think that was in relation to whether a commercial interest.
Yeah, that's a very, very good question. Essentially, what can be said if you have, for example, a joint venture between the research institution and the public research institute, sorry, the research institution and the private company. The private company holds 51% of the shares of this joint venture, for example. In this case, you would say that it has a decisive influence. There might be other means of influence depending on the contracts they have. So if the private company has the right to direct the research in a certain direction, then this would probably also constitute a decisive influence in this case. A very good question, but by the way. All right. So let's move to the second element of this regulation. Text and data the AI training must qualify as text and data mining, and this is very, very controversial, as I just said. What Section 60D of the German Copyright Act does here, it refers to Section 44B of the German Copyright Act, which has a definition of commercial text and data mining, which is basically the same requirement. So if we are looking at 44B, we have here a definition of text and data mining. It is defined to be the automated analysis of individual or multiple digital or digitized works in order to derive information from them, in particular regarding patterns, trends, and correlations. And the question here is what means to derive information? What information is included in this or is meant in this definition? And to clarify on that, I would like to give you three scenarios. The first one is the lion case, which compared images with descriptions, so if they match or if they don't match. The second is a hypothetical case of a university that trains AI to detect tumors. They have a vast amount of pictures with tumors on it or not, and the AI is trained to detect them. And third example would be a university that trains AI on books, so it can write books in the end, which is a sort of generative AI. In these cases, they differ in some way. So the Lion case is clearly a text and data mining analysis because here it's not AI training, but it's kind of a preparatory step. The goal is to identify some correlations, and this is text and data mining in the classical sense. And also the tumor detection system would qualify as text and data mining because it's all about pattern recognition and creating knowledge in a way. The third example is different because here we have a generative AI that doesn't just learn patterns and it's not just generating knowledge, but it also learns to express itself like human. And like this expression, that's what kind of copyright is protecting. And if you train such a model, then the result would be that the model generates outputs that would compete with the very works that were used for training. And for this reason, there's a major debate about whether such AI systems would qualify as text and data mining, or, for example, in the US, if it's fair use to use, for example, books to train such models. And some say it's not text and data mining. So one argument would be that the legislator did not see generative AI coming, it did not want to regulate it, and that such generative AI systems are something that are fundamentally different to the other forms of text and data mining. And to be honest, I have some sympathies for this opinion. But the prevailing view is that also these generative AI systems qualify as text and data mining and are therefore permitted. So the bottom line for now is that all three cases constitute text and data mining according to the prevailing view. But I would also like to mention we are still waiting that these cases are decided by our courts. And until we don't have any judgments, things might change. All right. Let's assume that AI training qualifies as text and data mining. And you have in section 44b of the German Copyright Act another requirement: the works must be lawfully accessible for you who is reproducing the data. And this requirement is actually interpreted very broadly because it only looks whether the access itself is lawful, which means in practice that anything that is available in the internet that can be scraped counts as lawfully accessible. So it doesn't matter, for example, whether the rights holder consented to the content to be being posted online, or if you have like on a website certain terms and conditions that prohibit scraping of this information. Even if you have such terms, the access would still qualify as lawful, at least under the prevailing view, because these contractual prohibitions cannot override the exceptions. What would not count as lawfully accessible are technical protection measures. So if you need to go around technical protection measures, if you need to bypass paywalls without paying for them, in that case, this would not be lawfully accessible. And there is an open question. What's about obviously illegally posted content, such as privacy on privacy platforms, for example, piracy platforms, sorry, that hasn't been decided yet. So if you just look at the regulation, then you would say, it might be still lawfully accessible, but it might also be that a court would say that this is something different if it's like an obviously illegal platform or that's hosting obviously illegal content. Right.
Sorry,
Yes.
there is another question. I think
Yeah, great.
it just came in relation to what you were discussing. What
Yeah.
qualifies as a technical protection measure?
Well, I don't know if there's a real law standard for it, but anything that prohibits you from accessing this content. So if you have, for example, a paywall and you have any technical measures to bypass this paywall, or what's basically like if you need to hack into something, what I say from my non-technical perspective that you are hacking something. But if you can't access it just by opening a website, then this would be a technical protection measure. On the other way, if your institution is paying for access and you are accessing the data using your institution access, then it would be lawfully accessible for you, according to the prevailing opinion. So there's also some debate about it. But yeah, this would constitute as being lawfully accessible. Right. Also a very good question. And yeah, so if you have these elements fulfilled, then you have some last limitations in the exception, that the reproduction must be made for the text and data mining, so for the training of the generative of the AI, and it must be for scientific research purposes, which is kind of self-explainable. So first of all, the copies, they must be made just for the purpose of the AI training. So they can only be used for training this particular AI and not for something else. If you want to use the copy for something else, you need a separate legal basis. And the AI training must be for a scientific research project. And this is particularly relevant if your research projects later transitions into a commercial exploitation. So, for example, if you have a spin-off out of your research project, then it's very likely that the authorization under Section 60D ends. So if you feel, oh, my research project might be relevant for commercial purposes, and you change the purpose of your whole project, then yeah, this might be the case that the authorization ends. And then you have like what I explained as project specificity. yeah, you are only allowed to keep your copies for a certain time as long as it's relevant for your research. And literature infers from that requirement that the copy must be done for a concrete project connect. Also, it needs to have a concrete project connection. If the data is not required for your project anymore, the data must be deleted. So, as a practical matter, it might be useful to create a deletion plan for the copies. So to prepare in unlikely event of a lawsuit that you can explain why the copy still exists because it's necessary for your project. Right. So this is basically the commercial, for scientific research purposes, the exception. Um, I see there's another question in the chat. Should
Yeah,
we?
exactly. For technical protected material, what are the laws regarding if, for example, two institutes are working together and one institute has a subscription to a data set, but the other institute does not? Oof.
Okay, very good question. Yes. Well, I'd say I can't really answer on that because this is like kind of a specific case where you really have to look into the details and how this is kind of organized between the two institutions and who is basically using it. So if you access yeah, I would say just like if I had to guess, I would say if the first institution one is accessing the data legally and then is makes the data available to institution two, it should also qualify as lawful access, if I had to guess, because it's not you're just looking on the access itself and not whether the one who owns the data or has the data has consented to making the data available. That's also the discussion about this piracy sites. So there are voices in literature that say, yeah, it's lawfully accessible, even if it's obviously uploaded without the consent of the rights holder, just because you don't need to bypass any technical protection measures. You have access, so you can use it. Yeah, I hope this answers the question. Also a good question, but yeah, I mean, I what I say is very general. What things to bear in mind when you're setting up research projects. But these questions they come up when you have a specific case, and then they must be assessed individually. Yeah. Just for completeness, I would like to mention also the commercial text and data mining exception in 44B of the German Copyright Act. So if you don't qualify as a research organization under Section 60D, there's this similar exception in Section 44B. And the requirements are almost the same. So you need reproduction, you need text and data mining, which is AI, training under the prevailing opinion, you need lawful access, but you have another additional requirement that is that the rights holder must not have reserved their rights in a machine readable format. So this is called an opt-out, and it's usually done through a robot TXT file. And if someone has declared his or her opt-out, then you are not allowed to reproduce this information. And here's the key difference between 60D and 44B. The privilege for scientific research is much stronger because there's no opt-out possible for scientific research. So rights holder cannot block scientific text and data mining by opting out of the AI training, for example. Right. So in general, training or the compilation of training data is possible for scientific research if you lawfully accessed the data. And let's assume that everything here, this is the case. So we move further and have a brief look at the other phases here, which would be the training and the output. And I would like to take the phases out of order and start with phase three because it's important to understand phase two because the real legal risks come here basically. So the output can also constitute a copyright infringement if the output or the model reproduces in the output the training data, the works, in the exact or slightly modified form, then this would also constitute a copyright infringement. And several types of infringement can come into play here. It could be, again, a reproduction, if it's the exact copy. It could also be an adaptation, so a modified version of the original work, where elements of creativity of the original elements are still recognizable. And it would also constitute another use, making it available to the public when this model is used in the market. And what's very important here, there is no real exception that can justify this. So even if the reproduction was not intentional, even if the model is trained to not reproduce the work, if it does, and that's exactly what happened to OpenAI, then this constitutes a copyright infringement. And yeah, that's basically why it's so important to make absolutely sure that the model does not reproduce copyrighted training data. Otherwise, there would be a risk of being sued for injunction or damages. And this phase 3 is very important for the second phase, because we can also ask ourselves if there are any copies during training. And if there are copies, are they authorized by law? And yes, there are temporary copies that are being made during training. So even if someone is just briefly moved into the RAM, counts as a copy, but that's covered by Section 44A as a temporary copy. So that is allowed. What the real question is whether the works are stored inside the model. And if you speak to computer scientists, they say no, works are not stored inside the model because they are not stored in a traditional sense. And it makes perfect sense. So an AI model does not store the training data. Data is broken down into tokens, and these are used to train the connections. So this is not like saving information or copying information in the classical sense. However, legal literature and case law see it differently because they're not coming from a technical perspective. Just recently, the Munich Regional Court in GEMA versus OpenAI. The reasoning behind this is that it doesn't really matter how you represent information. What matters is just that information is stored in a way that it can be made perceptible to human senses. So, and here's then the link to phase 3. If a model regularly outputs training data, this constitutes a copyright infringement on the output side. But courts will infer from that phenomenon that the works are also stored, kind of represented in a new form inside the model. That's called memorization. And yeah, they understand reproduction as technology neutral. It's only relevant whether the information is represented in a form that can be made perceptible to human senses. And once again, you have, in this case, a potential infringement. You have a copy that cannot be justified. Especially Section 60D and 44B don't apply because you don't have a reproduction for the purpose of text and data mining. But this memorization is the result of text and data mining. And other exceptions are also not available here. The consequences are really serious. What just happened to OpenAI is that an injunction was granted. So OpenAI has to remove these copies, these reproductions from the model itself. And it's not sufficient to just implement a filter that stops copyright infringing output. You need to kind of delete the information from the model itself, which means either machine unlearning, which as far as I know is quite difficult, or you have to retrain the model from scratch. Yeah, this is hugely debated. I think it's not quite, I don't know. I'm not really happy with this judgment in that sense, because I think there are consequences that are very far-reaching. But right now we have this judgment here. So if you allow me some concluding remarks, this is probably the risk that you are running into if you're training a model for research purposes. So when you stick to a law, then training and all the preparatory steps, compiling the training data, that's all possible. But you need to make sure that you don't have any output in the end, especially when you put your model on the market, or you publish it on Hugging Face, or I don't know, on GitHub. You don't want to be have this model output infringing content. So I see some question, but I would just have this last slide, and then we can just go right into the discussion. Just a short output to keep an eye on. So we have several cases before our courts. We have the Lion case, which is now pending, as far as I understood it, before the German Federal Court of Justice. GEMA with OpenAI is on appeal before Munich Higher Regional Court. There's another OpenAI case pending also before the Munich Higher, no, before the Munich court in the first instance. And we have preliminary reference to the European Court of Justice. So we can expect some judgments in the near future. And also, US legislators becoming active, basically legislator all over the world, also in UK, they are becoming active. So we can expect that the rules will change here in this particular area. Yeah. So that was my just brief overview on these topics. Thank you very much for joining and your attention. And I would just say we could go into the discussion now.
Yes, thank you very much, Pascal. It was very thorough and very informative. Chris, you may stop the recording now, and then I will